The International Criminal Court ICC is scheduled to confirm charges against Joseph Konny on 9th September 2025. Despite outstanding warrants, his whereabouts remain unknown. Joseph Konny faces charges of war crimes and crimes against humanity committed in northern Uganda between 2003 and 2004.
As it were, dispel a few myths that appear to be prevalent about what is going to happen on September the 9th. What is a confirmation of charges and what it is not, and what you will see on September the 9th and the following days. Now, a confirmation of charges is a process which ordinarily, and here in Kampala, would take place behind a closed door in the offices of the Attorney General, and would involve nothing more really than a signature on a piece of paper saying, I believe these charges are good enough to go to trial. That's what a confirmation of charges is. And in most national jurisdictions, that's all that happens. A senior prosecutor looks at the evidence and says, yes, that's good enough. The ICC, of course, does that publicly, but it's important to bear in mind that's all that's happening on September the 9th. At the end of the process, nobody is going to be found guilty. Nobody is going to be sent to prison. Nobody is going to receive compensation. And I think that's important to bear that in mind, because a lot of the material we read in the media here in Uganda continually uses the phrase, the trial of Joseph Konny. What's happening on September the 9th isn't a trial, it's a confirmation of charges, something that would normally happen in an office. And what are you going to see? Well, you're not going to see anybody give evidence. The judges have already decided that that's not necessary. They will make the decision on paper. So what you will see on September the 9th and 10th is lawyers arguing about whether the evidence on the papers is good enough to sustain the charges. And bear in mind that those are the same charges, really, that have justified the arrest warrant being issued against Mr. Joseph Konny. So even if these charges are confirmed, the position of Joseph Konny is completely unaltered. He will still be subject to an arrest warrant. He'll not be subject to any further restriction on his liberty. He'll not be subjected to any punishment. So it will make no difference to him, and it will make no difference to the victims. It's a largely academic exercise that moves the case from there to about there. So I think it really is important that you bear that in mind. This is not a trial, and it's highly unlikely that there ever will be a trial of an accused who is not before the court at the ICC. So it's a limited exercise that probably will go no further. Now, lastly, and I am going to hand over to our team now, is the question, which I'm sure has exercised many of you, is what would happen, assuming he is alive, and I think we all do assume he's alive, if Joseph Konny walks across the border into northern Uganda and puts his hands up at the nearest police station and says, I'm here, I surrender. And I think that's important given what Chris has been talking about and all the other things we've said. And Lillian, the team's going to deal with that now.
Thank you very much, Peter. Good morning, everyone.
His lawyers are challenging the legality of a pre-trial in his absence.
If Konny returns to Uganda, clearly when he returns to Uganda, he'll be arrested and put in custody. We all know that Uganda has since established an international crimes division, which is based in Kampala. This criminal division, the International Crimes Division, has jurisdiction over all matters, most of the matters that the ICC is actually tackling. The International Crimes Division has jurisdiction that has been driven from the High Court International Crimes Division, Practice Direction 2011, which formally establishes the ICD and its mandate. Also, the International Criminal Court Act 2010, which domesticates the Rome Statute into the Ugandan laws. What does this mean? This actually means that the crimes that are ably tackled by the ICC can be tackled by the International Crimes Division here in Uganda. That means with Konny being arrested and kept in custody in Uganda, he will be able to be tried by the International Crimes Division, whose jurisdiction over matters such as genocide, war crimes, crimes against humanity, and terrorism, among others, can be held or heard by that court. So in light of that, I'll also refer to the principle of complementarity, which requires that the national court here allows or is in agreement that the ICC is in agreement with the Ugandan National Court that it is able and capable of prosecuting the international crimes committed by Joseph Konny. I'll also add that the offenses committed by Konny, as noted in the charges, are basically war crimes and crimes against humanity, which will be ably handled by the court here. So with that, we believe that if Konny is allowed or is apprehended here, he can easily be prosecuted in this court. The International Crimes Court has ably demonstrated that they are able or they are capable of handling such matters. We've seen the case of Thomas Koyelo, which has been well handled, despite the few challenges that would be experienced anywhere else. With that, I believe that if Konny is apprehended here, he will ably face charges and tried by the International Crimes Court other than being tried in the ICC. In fact, it will also give most of the victims here and all the witnesses to hear or be part of the proceedings, unlike if this trial was held in the ICC. Yeah, I think that's it.
In total?
8.
And they're not all lawyers, yeah. There are support staff, people who manage the case. It's an enormous case. The answer to your question is, I think we have it from the highest authority that if in 2025 Joseph Konny were to be arrested in Uganda or returned to Uganda, he would face justice here. Without being too explicit, I think we have received that assurance from the highest possible authority. The other point I wanted to make, and a lady down there asked about victims, and this goes to something Chris said. The ICC case is really very, very limited. It concerns 6 crime sites. I think within the investigative files that were handed over, it comprises 8 files from the Ugandan investigators. They hold 800 files against Joseph. So it's a very small percentage of the things he has said to have done. And the ICC cannot try him for the others because they happened before 2002, or they concern crimes such as terrorism, which are not within the ICC's jurisdiction. So one of the reasons that I think people in the north are concerned about this process is because it's divisive. Only the people who are victims of those files that are before the ICC, if ever it came to trial, which it probably won't, will receive compensation. None of the people who were victims of crimes between 1988 and 2002 will be covered by that. And so it will, in the community of the North, be divisive, because there will be those who are lucky and those who are not. So I just wanted to mention that because somebody down there mentioned the question of victims.
9 senior defense lawyers have been assembled for the case
of the ICC's case against Joseph Konny, because I understand that you all would know that it is a long history. This is not a case that just appeared in the last year or so. The ICC, in fact, first sent or received a referral letter from the government of Uganda in January 2004. So over 20 years ago, the Ugandan government sent a letter to the ICC referring the case to the court in The Hague. And it was this letter that then allowed the ICC prosecutor's office to investigate the allegations of crimes that had occurred in the north of Uganda. And so this letter that the Ugandan government sent in January 2004 is very interesting because we see that the Ugandan government didn't think that Uganda was incapable of investigating the case itself. They didn't think that the Ugandan judiciary was incapable of putting Joseph Konny on trial, but instead the letter talks about needing the assistance of the ICC in finding Joseph Konny and arresting Joseph Konny. And so this letter talks about this as being the primary reason that the Ugandan government referred the case to the court 21 years ago in 2004. It needed the ICC's help in finding and arresting Joseph Konny. So on the basis of that referral, the investigators and lawyers in the Office of the Prosecutor then investigated the crimes and then found there was sufficient evidence to submit a request for an arrest warrant against Joseph Konny and others. And the judges considered that evidence and agreed and issued an arrest warrant against Joseph Konny in 2005. And in fact, this was the first ever arrest warrant that was issued by the ICC. But since then, as we all know, the ICC has not succeeded in finding and arresting Joseph Konny. Despite long-term efforts, significant efforts, including by US military personnel, Joseph Konny remains at large. And that's how things remained until 2023, when the ICC prosecutor, Karim Khan, filed a request to the judges to hold a confirmation of charges hearing against Mr. Konny in his absence. And the prosecutor said, all right, after 2 decades, we think the ICC should decide to move against Joseph Konny in his absence. So even though he has never been arrested and he's never appeared before the court. The ICC should have a look at the evidence, the judges should consider the evidence that we've collected and decide whether or not there's sufficient evidence to confirm these charges. And for us in The Hague, this was a hugely surprising development. You know, this has never been done before. The ICC has always previously considered that a suspect, that someone against whom an arrest warrant has been issued, should appear at the court, should turn up and be arrested and surrendered to the court and make an initial appearance before any in absentia proceeding can be triggered. So the pre-trial chamber judges considered the request of the prosecutor and decided that yes, for the first time the ICC will engage in this novel exercise and have a hearing against Joseph Konny in his absence. So that's the background to the current proceedings. And maybe I'll talk a little now about what we've been doing since we were assigned, or Peter was first assigned a year ago in July of 2024. And it really comes down to the pre-trial chamber. When they made this decision and said, yes, we agree that there should be an in absentia hearing, the judges of the pre-trial chamber found that they were satisfied of two things. The first thing they found was that the ICC statute and ICC rules allowed for an in absentia confirmation hearing. And secondly, they decided that they thought this would be a good idea, that there were grounds to move against Joseph Konny in his absence. But only once they'd made those decisions and decided those things did they then turn to the assignment of counsel. So Peter was assigned after those decisions had been made by the court. So our team wasn't present and making any arguments at the time that those critical decisions had been made. So what have we been doing since our appointment? Well, as you heard, we haven't been talking to Joseph Konny. Our mandate is to represent his interests, not to go and try to find him and engage with him. So normally at this phase, the vast majority of our job would be talking with our client in detention and receiving his instructions and his input about the charges against him. But in this case, that is not our role. We don't have the ability to communicate with our client and receive his instructions. So instead, what we've been doing is looking into these two big overarching questions. One, is this process legal under the ICC statute? And two, is it a good idea for the ICC to take these steps, even if legally it can? And on the first question, is this legal under the statute? This is a legal question, and we did a lot of research and filed lengthy legal submissions in front of the court and to the appeals chamber, arguing that in fact, in our view, the ICC framework was never set up to try people in their absence or to move against people in their absence. So that was the first thing, and that ended with a decision, a recent decision of the appeals chamber affirming the pre-trial chamber judges and saying, we accept that we can move against someone in their absence. For the second question, is this a good idea? We have had the absolute privilege of spending as much time as we've been able in the north of Uganda and speaking with people about whether they think an in absentia hearing in this context is a good idea for the community. We have spoken with religious leaders, we've spoken with traditional leaders, political leaders, we've spoken with victims advocates, victims groups, we've spoken with the legal community, with defence lawyers, prosecutors, judges, and we've spoken with returnees, people who have even recently returned from the LRA camps, and asked them if they think having an in absentia confirmation hearing in the ICC moving against Joseph Konny, even though we don't have him in custody, is a good idea. And we took written statements from a lot of these people and submitted it to the pretrial chamber and asked them to really consider whether this is something that will be helpful for the community in northern Uganda that has taken such significant strides itself towards healing and reconciliation. So that has been the majority of our work since we were assigned last year, and it's work that we've found incredibly interesting and a real privilege to engage in. As Peter said, it's very strange for us, this process of representing someone in their absence. It's not something that we've done before, and there isn't a lot of precedent on how we can do it. But so far, that is how we've chosen to engage and use our energies so far in this case. So maybe now I'll pass to our colleague Christopher Gosnell, who's going to talk a bit about the court's operation and its limits and its jurisdiction, and the scope of the ICC's case against Mr. Konny.
Victims and observers question how justice will be achieved without the accused Joseph Konny.
Directed most of our energies towards was going and engaging with the communities in the north and asking them whether they agree with what the judges of the ICC have found, namely that there is good cause. That's the phrase the judges use. There is good cause to proceed in the absence of Joseph Konny. But I never said, and was careful not to say, that the communities that we spoke with in the north thought that it was a good idea, because that overwhelmingly was not what we were told. And so we took a lot of time to sit down with religious leaders from across the different faiths, and we sat down with the political leaders in the north, we sat down with the traditional leaders, and we met with victims groups, victims council, and we took written statements from them detailing what they thought about the ICC's involvement in this case. And I would really invite you to have a look at all these statements, which we filed publicly. And you can find our filing on the ICC website. Its reference number is 583 in the case, and it was filed on the 3rd of April 2025. And in that filing, we set out the real concerns that we heard from people in the north. And these concerns include that they're worried that reigniting this case against Joseph Konny will prove difficult for the community, who has worked so hard to reconcile amongst themselves. We heard a lot of people tell us that they would prefer that the ICC instead concentrated on making sure that the reparations that have been promised in the Ongwen case is being paid, rather than moving towards a new hearing in the Konny case. We heard people who told us that they would prefer that rather than Joseph Konny being moved against at the ICC, that he should return to Uganda and engage in traditional justice processes like macho put in the north. None of these positions come from us. All we tried to do was collect the information that we were learning, and so privileged to learn in the north, and put it in written form and submit it to the judges. So if you see this filing on the ICC website, you will see that we are not saying that this is a good idea, that we are not saying that the court should or should not engage. What we've done is we've asked the judges to consider more deeply the views of the people in northern Uganda, because they are the ones who should have the right to decide how this story ends. We know that it started in January 2004 with the referral of the case to the ICC, but it must be for the people of Uganda, and in particularly the victims in the north, to decide how they want it to finish. So we saw that as our job, as really expending our energy to collect all these views and then present them to the court. And I was asked, whose decision is it? Ultimately, now that the ICC is seized, it's a decision for the ICC judges. But if you tune in on the 9th of September, we will certainly be re-emphasising that we believe the court should be listening more to the communities in the north about what justice looks like to them and what justice means for them.
Yes, it's really difficult. We have been put in a situation, of course, I volunteered for it and I got it, but we've been put in a situation, literally, that no lawyers have ever been in before. So what do? Do we say, oh, our codes of conduct make this very difficult, so we'll walk away? No. What we will do, and the lady who asked that question I think is behind the cameras, what we will do at the confirmation charges hearing is act like lawyers. We will put the challenge to the confirmation charges that is legal, but what it will not be based on the assertions of our client that he wasn't there, that he didn't do this, that he didn't order this, because we don't know whether that's what he would tell us. And that's really difficult. He might actually tell us, you know, I'm sure you've all thought this, he might actually tell us, I did all this, I'd like to plead guilty. And so actually advancing a positive defence on his behalf that we've invented would be quite wrong, because we would be prejudicing his position, and that would be a breach of our codes of conduct. So acting within our codes of conduct, we will present legal arguments at confirmation charges hearing, because that is all we've got to do. Everybody at the ICC is paid. Maria's paid. You don't ask her salary, so I'll give you a short answer to that question. Mind your own business. Now, I think I've dealt with everything apart from the question that was directed to Kate, which I think was based on a misconception that she can deal with.
Yes, thank you very much.
Joseph Konny, via the Lord Resistance Army, is accused of atrocities in Lira, Guru and Soroti. In 2014, Joseph Konny allegedly offered to appear if the International Criminal Court lifted its arrest warrant, an offer never realized. In April this year, Joseph Konny's family returned to Uganda after peaceful talks with the Central African Republic